Good morning, folks, and welcome to the second in our series here at NJVOAD of our summer webinar series. And it's our pleasure today to have Sue Wu. Sue is an assisting managing attorney with Northeast New Jersey Legal Services and has been a good friend in NJVOAD. And of course, they're also members of our organization. And we rely upon them heavily in times of disaster to provide legal services to clients and organizations who are involved in response and recovery. So again, welcome. Glad to see you all here this morning. So with that, Sue, again, good morning. Glad to see you here, and it is all yours.
Thank you, Keith. I am really happy to be here and be able to present to everyone about people's legal rights in the face of a disaster. This is a presentation by Disaster Response Project at Northeast New Jersey Legal Services. My name is Sue H. Wu. I am a supervisor of Disaster Response Project and also assistant managing attorney for our housing unit. Northeast New Jersey Legal Services is a private, nonprofit, public interest law firm that provides free legal services in civil matters to low-income and underserved individuals and families. We serve 3 counties in New Jersey: Bergen, Hudson, and Passaic. We also work to increase the public's knowledge of their legal rights and responsibilities through community legal education. Our mission is to ensure equal access to justice for low-income residents of our counties that we serve. And it is our belief and value that no one should be denied a meaningful opportunity to have their day in court simply because they cannot afford a lawyer. These are some of the areas that we provide legal services, like public benefits, consumer, domestic violence, elder justice, education, family law, veterans, taxes, immigration, and reentry. I'd like to introduce our Disaster Response Project. It is the newest program at NJVOAD, and our primary goal is to provide legal assistance to victims of natural disasters. Currently, due to our current LSC grant, our main priority is to assist the victims of Hurricane Ida. However, we will provide assistance to anybody who is a victim of any disasters. Why is disaster assistance important? As many of us know, disasters are increasing in frequency and cost. During the last summer, 1 in 3 Americans experienced a weather-related disaster of some sort. Hurricane Ida hit northern New Jersey in September of 2021 and was the 4th largest and most costly Atlantic hurricane in US history. As climate change worsens, we can expect disasters to happen more often and to cost more when recovering from them. Who are the most vulnerable when a disaster strikes? Low-income individuals, people with disabilities, people with functional and access needs, rural or marginalized community members, racial and ethnic minorities, children, youth and adolescents, older adults, evacuees, and homeless people. When I started doing the disaster work, I was very shocked to learn that even in a disaster, which does not discriminate when it strikes any area or community, during the recovery period, unfortunately, all these vulnerable community members suffer a lot more unproportionally. They are discriminated in applying for government benefits. They are discriminated against by various prejudices that are built in our society. Therefore, it is our intent to be able to help these vulnerable community members. I will start by defining what is an emergency versus disaster. So Stafford Act, which is a federal statute, defines emergency as any occasion or instance for which, in the determination of the president, federal assistance is needed to supplement state and local efforts and capabilities to save lives and protect property and public health and safety, or to lessen or avert the threat of catastrophe in any part of the United States. FEMA defines emergency as any occasion or instance that warrants action to save lives and to protect property, public health, and safety. Disaster is defined as, according to the FEMA definition, an occurrence of a natural catastrophe, technological accident, or human-caused event that has resulted in severe property damage, death, and or multiple injuries. So disaster is much more severe in degree than emergency, and the definition makes it very clear. The same Stafford Act defines disaster as any natural catastrophe or regardless of cause, any fire, flood, explosion in any part of the United States, which is a determination of the president, causes damage of sufficient severity and magnitude to warrant major disaster assistance under this act to supplement the efforts and available resources of the states, local governments, and disaster relief organization in alleviating the damage, loss, hardship, or suffering caused thereby. So what is the difference between emergency and disaster? So emergency declaration is made when a threat is recognized. They're both made by the President of the United States. And the emergency is intended to supplement and coordinate local and state efforts prior to the event, such as evacuations and protections of public assets. The emergency declaration assistance cannot exceed $5 million per incident. And the focus is more on the prevention. Whereas disaster declarations are made as a result of a disaster or catastrophic event. So it constitutes a broader authority that helps states and local communities, as well as family and individuals, to recover from the damages caused by the event. So the focus is more on the recovery. Federal disaster declaration process has very specific steps. So how do we get a major disaster declared? You probably have seen the president appearing on TV and saying, I declare that area or state as a disaster area. Why is that necessary? Because that activates the federal funding that will be available for assistance. So the process is a bottom to up process. So the first step is local government. After an incident occurs, the local government assesses the damage and makes a request for assistance to FEMA's regional administrator. So all the 50 states in the United States are divided into different FEMA regionals, and they have an administrator for each region. All requests for the major disaster declaration must start with a request from the governor of the affected states. Once the request goes up to FEMA regional office, state and federal officials conduct a preliminary damage assessment. So you will see governor officials visiting the site of the damage to assess the extent of it and to estimate it. If merited, FEMA regional administrator elevates the request to the FEMA headquarters. So FEMA headquarters receives the governor's request and make a request to the Department of Homeland Security. Once the request is received by the Department of Homeland Security, DHS sends it over to the White House, and the president makes the final decision to declare a major disaster based on the governor's request. FEMA is the federal government agency that handles major declared disaster assistance. There are 3 different components: public assistance, individual assistance, and hazard mitigation. My presentation today will focus mostly on individual assistance as those are more relevant issues when we try to help our community members. FEMA recently reformed its individual assistance program. This is FEMA implemented the most significant updates to disaster assistance in the last 20 years. And these updates include, first, flexible funding to provide directly to survivors when they need it most. It has been known to everybody who are involved that the FEMA sometimes does not provide the funds immediately or soon to the affected survivors when they are in dire need of it. So there are, the FEMA has updated the program to be more flexible so that the funds can go directly to survivors when they need it the most, which is usually immediately after a disaster. FEMA also expanded eligibility to help more people recover faster. And they simplified the application process to meet survivors' individual needs. For example, before this new update, individuals had to apply for something called small business loan, although they didn't really need a loan because that was part of the application process, but FEMA now eliminated that process. So these changes apply to disasters declared on or after March 22nd, 2024. At least in New Jersey, we have not had a major disaster since the update, so we have not had a chance to see how these new reforms are put into effect, but we will find that in the future. The individual assistance component of the FEMA program involves these major programs. First, mass care and emergency assistance. Those involve providing shelter, feeding, and mass evacuees right after a disaster occurs. Individuals and household programs assistance involve providing temporary housing and providing funds to repair houses, hazard mitigation assistance, and also for uninsured or underinsured expenses. Disaster case management is a program to provide supplemental award that are made to state, tribal, or territorial government or non-government organizations so that they can assist the victims of a disaster. FEMA also provides for crisis counseling assistance and training programs. They also provide disaster legal services and support organizations like us so that we can provide legal services to local communities. FEMA also provides for disaster unemployment assistance for people who are either displaced or their jobs are no longer available due to a disaster. And also FEMA organizes for voluntary agency coordination so different agencies can come together and try to expedite the recovery process. FEMA's general eligibility for individual assistance I listed below. Number one, but since this is a federal program, an individual has to be either a U.S. citizen, non-citizen national, or qualified alien. They have to have a verifiable identity through a valid social security number. And they must have suffered economic damage that are uninsured or underinsured. And the needs of the victims must be directly caused by a declared disaster. And the victims must be able to prove their occupancy of the unit that we're living in or the ownership of the property that were damaged. I will cover legal issues that arise in a disaster. When people hear a disaster, legal issues do not immediately arise in their minds because people are used to thinking about shelters, medical assistance, food, water, and things like that. But many different legal issues do arise in a disaster. Those legal issues can be classified into 3 categories depending on the timeline. So short-term issues arise within immediately after disaster up to 3 months. Those issues involve housing, document replacements, and applying for federal or state disaster assistance. From 3 to 6 months, medium-term issues arise in the area of housing, consumer issues, family, and education. And after 6 months, long-term issues still may linger, sometimes for many years, involving housing, consumer, civil rights, and others. Legal issues that arise in a short term. When a disaster strikes, usually the first thing that happens is people are displaced from their homes. So the housing issues arise for renters as well as for homeowners. Second, when a disaster is very severe in nature, sometimes people have to evacuate without being able to take anything with them, and they may lose all the important government documents and IDs. So documents have to be replaced in order to collect different benefits and even find a temporary place to live. They're going to have to be able to provide some type of identification documents. Applying for public benefits have to be taken care of. Consumer issues arise because if disaster victims cannot continue to pay their monthly bills, creditors will start making claims against them. Emergency unemployment applications have to be filed. Education issues arise if children are displaced from their homes and they're no longer able to attend their regular school. So if they have to go to a school in another area, those things have to be arranged. Family issues can arise if there is any child custody issues. If one of the parents can no longer provide a safe home for the child, arrangement must be made accordingly. And healthcare access also becomes an immediate issue after a disaster. In the medium term, housing issues continue for habitability issues for renters. If the renter continues to live in the same unit that was affected by disaster, they may have issues such as mold or damaged floor or any part of the apartment, and these things have to be taken care of. For homeowners, housing repair issues occur, and some of the repairs may take longer than a few weeks or months, because usually after a major disaster, the demand for home repairs in the area becomes so huge that it becomes difficult to find supplies or the contractors to do the repairs. Insurance claims and appeals have to be taken care of within those times. I will cover the insurance in more detail in later part of my presentation. FEMA applications are usually filed immediately after a disaster because there is a 60-day due date. However, if FEMA denies any claims, appeals have to be filed within 60 days. And it's important to submit these applications timely. Public benefits also may be denied and appeals have to be filed in a timely manner. Consumer issues, employment issues, education issues may linger on, may extend from a short term to medium term, especially when an issue involves more complicated legal issue. And these are the times when attorneys can provide assistance with legal issues. Family issues and also estate planning and probate issues may arise if there are any unfortunate situations where victims have lost their lives and their properties and assets must be probated in the proper court. Long-term issues arise, especially for homeowners. Property title may become an issue if the affected homeowner does not have a clear title to the property. We see less of this in our area, but unfortunately in the states that are in the South that have historically had rules against African-American citizens to have a property under the name, Properties were just passing down the generations in the family without ever having a clear title. So when the property is damaged from a disaster and the current owners try to apply for government benefits, such as FEMA, it becomes an issue because the owner needs a clear title in order to receive those benefits. So the attorneys do help out in cases like that. FEMA has a recoupment program, which is if they paid out benefits to survivors more than FEMA thinks was correct, they may ask the recipient to pay back the money that was overpaid. And these may involve some complex evidentiary and other issues, and legal services may be able to help in those cases. During the home repair period, unfortunately, there are many contractor fraud cases that involve legal cases. Foreclosures, mortgages all involve legal proceedings, so the attorneys are needed to handle those cases. Consumer issues arise if survivors are not able to continue to pay their debts, and the case goes to collections. And the final stages of collecting against a debtor by garnishing wages or levying their assets and bank accounts. In the long term, civil and disability right cases may arise. Unfortunately, historically, we have seen many cases where vulnerable community members were discriminated against during the recovery period for various reasons. So these may involve civil rights cases. I will be covering some of these legal issues in more detail because I can't possibly cover all of them, but these are the areas that are most likely to be seen and where many people have questions about. The first is landlord-tenant issues. Second is document replacement. Third is applying for public benefits. Fourth involves FEMA applications. Fifth is disaster relief insurance basics. And the sixth is about contractor issues. Landlord-tenant issues. If a full home is flooded, what can a tenant do to break their lease? So if a home is flooded and becomes uninhabitable, then the tenant can obviously no longer live there and is no longer under an obligation to continue to pay the rent. And they do have a right to break the lease. What notices needs to be sent? So tenant must notify the landlord why they are breaking their lease and why they are no longer able to continue to live in the unit. How can a tenant get a security deposit back? New Jersey has Security Deposit Act, which I will cover in a little more detail in the next slide. And in a case of an emergent displacement, landlords are required to return the security deposit within 5 days, as long as the tenant does not intend to continue to live in the unit and they are ready to move out. If the tenant will continue to live in the affected unit, how can they have their portion of the rent deducted? This would be covered under what is called warranty of habitability. So in New Jersey, any rental unit has to comply with the warranty of habitability, and the landlord must make sure that the condition in the apartment is such so that the tenant who pays rent and lives in the unit should be able to, enjoy living in the unit without any danger or unsafe condition. And the unit must be kept in a relatively safe condition. So if a unit is damaged and the tenant is not getting the full benefit of their rental unit, they are entitled to withhold their rent if the landlord refuses to make the repairs. It is provided specifically for tenants who are covered by what is called Anti-Eviction Act. So Anti-Eviction Act is a tenant protection law in New Jersey, and it applies for most of the tenants who live in a unit that is not occupied by the landlord or the owner. And it provides a lot of protection for tenants. And tenants cannot be evicted unless landlord has one of the valid 18 grounds to evict a tenant. And under the Anti-Eviction Act, tenants can withhold rent until the landlord makes the repairs. Usually, when tenant starts to withhold rent, landlords would take the tenants to court for non-payment rent, and the tenant should save up the rent money and deposit with the court's escrow account and request something called a Marini hearing to determine if they're entitled to any reduction of their rent due to reduced services. So this is something that is available at any time, even in times of blue sky times. However, the same warranty of habitability would still apply after a disaster. If anything was damaged in the unit, not personal properties, but concerning the livable condition, tenants do have this right to withhold rent and take it to the landlord and tenant court. New Jersey also has a fire statute under New Jersey statute section 46:8-6. So when a building is injured by fire without tenant's fault, landlord shall repair as speedily as possible, and the rent shall cease until complete repair is done. So the statute provides that if a tenant is displaced due to a fire, landlord is supposed to make the repairs as speedily as possible and allow the tenant move back in. In reality, we see sometimes cases where a local fire happens or building collapse happens. It's difficult to enforce the statute because tenants have to have a temporary living option so that they can wait out until the landlord makes the repair. Unfortunately, many times tenants do not have that option, especially in the communities that we serve. Therefore, they end up just leaving the unit altogether and move on with their lives. But the fire statute does provide that the landlord has the responsibility to make the repairs as soon as possible and then allow the tenant to move back in. It becomes almost impossible to enforce if the landlord makes the repairs and have another tenant living in the unit already, because no judge will, evict the current tenant to restore the old tenant into the unit. Security deposit return. So New Jersey statute section 46:8-21.1 says, within 30 days after termination of the tenant's lease, the owner shall return the security deposit, plus the tenant's portion of the interest, less any charges expended in accordance with the terms of the contract. So in a usual situation, landlord has 30 days to return the security deposit after a tenant vacates. Landlords do have a right to deduct for any unpaid rent or any damage that were caused by the tenant that is beyond regular normal wear and tear. So if the landlord claims the tenant caused the damage that is not just due to passing of the time, they do have a right to deduct from the security deposit and return the remaining amount. However, if the tenant is displaced as a result of a disaster or any other type of emergency, landlord must return the security deposit within 5 business days. And the statute specifically states the tenant is caused to be displaced by fire, flood, condemnation, or evacuation, and others. The second topic that I will discuss is document replacement. So if victims of disaster leave with nothing on them, these are some of the documents that would have to be replaced, like birth certificate, driver's license, social security card, EBT card, state identification card, citizenship certificate, deed, and mortgage documents. Many of these documents take a long time, and usually the agencies that handle these documents will require some type of identification confirmation. So if someone doesn't have anything to start with, it becomes very difficult to replace these documents. After a major disaster, some government agencies make an exception and try to assist people by expediting the process, but attorneys can provide assistance how to do this as quickly as possible so that people can have proper ID, be able to drive, and apply for benefits and things like that. Lawyers can help clients in applying for food stamps, SBA loan application from FEMA, applying for different emergency assistance programs, and emergency unemployment benefits. So unemployment benefits are usually available when people are laid off from their jobs without fault. However, in a case of a disaster, government sets up a emergency unemployment benefit so that people can collect benefits without having to wait much longer process with the regular unemployment benefit application. FEMA is the first place that any victim should apply because it's important to have that FEMA application number for other programs later. However, even many months after a disaster, other special government funds do become available. And I want to share one specific fund that came into effect post Hurricane Ida. So Hurricane Ida hit northern New Jersey on September 1st, 2021. So it has been almost 3 years now. And soon after, Congress appropriated $5 billion in HUD money under a program called CDBG-DDR, Community Development Block Grant Disaster Recovery, on September 21st, 2021. So this was about 3 weeks after the hurricane had hit many different states. After some months, in May of 2022, HUD allocated $220 million to New Jersey, and DCA, Department of Community Affairs, became the agency that handled the fund. Because of all the processes that are required, it took some more months until the funds actually became available. So DCA opened a pre-application portal for homeowners to apply for Homeowner Assistance and Recovery Program, we call it HARP, from February 27, 2023 to May 1st, 2023. So this funding provided grants, actual money, to rehabilitate, reconstruct, and or elevate their eligible storm damaged homes, and also for structural, utility, grading, and slope stabilization and drainage repairs. This funding was available, but it was important for homeowners to know about it and file an application in order to receive this grant. At the same time, DCA also opened a pre-application portal for tenants called Tenant-Based Rental Assistance, and allow tenants to receive up to 24 months of rent into the future. And the application was open from February 27, 2023 to June 1st, 2023. Again, it was important for renters to know about this program and fill out an application online in order to claim the benefits that they were entitled to. This TBRA was available for residents of 7 most severely affected counties in New Jersey. And the 3 counties that we serve were all included in those counties. So the temporary housing was the part of the FEMA assistance from federal assistance from the Department of Community Affairs. It also provided for temporary housing, pays for a household who had to evacuate their home to rent a new place while repairs are being completed on their homes. And the payments are based on the area's median rental costs. So this was a temporary housing assistance available for homeowners who had to rent a temporary rental unit. The next topic I will cover in detail involves FEMA applications. So FEMA is a federal agency which provides disaster relief funds to individuals and families who were negatively impacted by a natural disaster. For displaced renters, they may be able to provide with temporary relocation assistance. For homeowners, they may be able to provide with funds to repair the homes. Again, lawyers can help victims to draft the application, which does have a 60-day deadline. It's very, very important for survivors of any disaster, if it's a nationally declared disaster, to fill out the FEMA application. You know, it's possible to fill it out online or even by phone, because not even if a victim does not receive FEMA benefits, the application number may be needed later on to file for other benefits. And it's also important for FEMA to know how many people were affected, because this data will help them to estimate the actual damages that were incurred in the areas that were affected. So we emphasize that everyone should fill this application out. After Hurricane Ida, I believe there were more than 70,000 applications were filed in New Jersey. Types of FEMA assistance. So FEMA provides housing assistance for home repairs, for rental assistance, lodging expenses for temporary living arrangement and hotels or other places. They also make reimbursements and replacement assistance. They may be able to provide for manufactured housing units and even help with direct leases. Other assistance based on needs involve assistance for damaged personal property, moving and storage expenses, funeral assistance, medical and dental expenses, childcare, critical needs, cleaning and removal assistance. FEMA has a list of items in standard price for each item. So the FEMA assistance is not based on individuals' actual lost or damaged item value. For example, if a refrigerator was damaged from a disaster and a homeowner bought it for $1,000, FEMA will not pay $1,000. FEMA has a list for a refrigerator and they'll only pay based on that list. And that's why once an application is filed, FEMA sends out agents to go to the affected homes and they do a determination and do an assessment of the damages. FEMA issues for homeowners. So for homeowners to receive assistance to repair their homes, it's important that they are eligible to receive the benefits. Homeowners must be able to provide that you actually own the property by producing title and proof that it's clear. and then provide that it is your primary residence. Homeowners who incur damages must also prove that the damages that they suffer is directly related to the claimed disaster. If the damages are result of a deferred maintenance of the home, FEMA will not pay for them. And homeowners, when they receive money from FEMA, they have to use it for the specific purpose that was provided. For example, if FEMA paid money to replace the roof, the homeowner have to use that money only to replace the roof. They can't use it to repair another section of the house or improve the basement unit or anything like that. The money has to be used for the purpose it was given, and homeowners should keep all the receipts and the proofs in case FEMA requests for audit. FEMA will not pay duplicate benefits if the homeowner received any insurance money to cover the repair of the damages. FEMA will not pay for the same damages that were already paid by insurance. Also, homeowners cannot receive money from another source for the same damage covered by FEMA if there are any local or state assistance that provided for the same damage. Then FEMA will not duplicate the benefit to the homeowners. So what happens if a victim has insurance and also applies for FEMA? So FEMA will not pay for repairs covered by insurance. However, once the homeowners receive their insurance award, there may be some damages that was not fully covered by insurance. So there may be grounds to appeal a FEMA decision if FEMA refused to pay anything and homeowner can show that it is actually not a duplication of benefit, but they're only claiming benefits for anything that was not covered by their own insurance. Housing assistance from FEMA. So this is money provided to a homeowner to repair a disaster-related damage to their home. And it can include both labor and the cost of the materials. When a homeowner wants to apply for this housing assistance to repair, they have to submit estimated costs of the repairs. We recommend obtaining more than just one estimate, but at least 2 or 3 estimates from different contractors to show that the amount is reasonable. And that is what is normal in the area. The goal is to make the home safe, sanitary, and functional so that people can move back in and live in the home safely. The goal is not to restore the home to the condition that it was before the disaster. So if a homeowner had a very high quality, expensive improvements in the home, FEMA will not pay to restore it to the condition that it was. It'll only pay up to the limit where they'll consider the home to be safe and sanitary and functional. FEMA may pay for tree removal to make the home safe if the tree hit the house and damage the home, such as removing the tree off the roof. However, FEMA will not pay to remove the tree if it only landed on the lawn or other areas of the property without touching the house. Other needs assistance. So this assistance is paid for other necessary and serious needs caused by the disaster. Those may involve medical or dental expenses, funeral cost, replacement of personal property, storage, auto damage, and things like that. So when someone applies for these assistance from FEMA, it's important to provide sufficient documents to substantiate the value of the lost items. For example, photos, receipts, things like that, to show FEMA the damage value. Appeals. So FEMA will issue a written decision determining what the benefits the applicant will receive once an application is filed and they have an opportunity to review it. If the applicant disagrees with the decision, they do have a right to file a written appeal. And this is found in the federal statute 44 CFR 206.115. The appeal needs to be postmarked or faxed within 60 days of the date of the notice of decision. Now, FEMA allows people to electronically file the appeals. The due date of the 60 days is enforced. However, when disaster strikes, things may take longer because the systems may be down, documents may be lost. So in some limited circumstances, FEMA will still entertain appeals that are filed after 60 days. And we have seen many cases where applicants were able to follow through the appeal that were filed late. So we recommend, even if it has been more than 60 days since the notice of the decision was provided, if there is a valid grounds to file an appeal, we encourage people to file the appeal anyway. And those appeal forms can be submitted online as well. So what should you include in the appeal? So the appeal needs to include at least the following basic information: a written explanation as to why the applicant does not agree with the decision. If the applicant feels that it's not a duplicate benefit, but the FEMA denied it on that ground, applicant will have to explain why and provide supporting documents. If there's any new information the applicant has, such as pictures of the damage, repair estimates, length of the repairs, or the receipts for repairs already completed, applicants should submit those with their appeal. It's recommended that homeowners to try to make temporary repairs as soon as they can after their homes are damaged, in order to prevent further damages or worsening of the condition. So people may be worried that if they start making repairs, insurance or the FEMA may deny their claims, but FEMA actually encourages people to make the temporary repair to prevent further damages. The letter must be signed by the attorney, and the applicant's signature must be notarized if an attorney is representing the applicant and submitting the appeal on their behalf. Spending the FEMA money. So the money should be used for the purpose that FEMA gave the money. FEMA recipients need to keep receipts about how they spent this FEMA fund. And FEMA can audit the FEMA awards for 3 years after the disaster. We have a client who received FEMA funding to replace her roof that was damaged from Hurricane Ida. It's been more than 2 years since she received the fund, but she was not able to replace the roof yet because she could not find the contractor who could do the job for the money that FEMA provided. And FEMA wanted to recoup that money from her. But we're helping her so that she doesn't have to recoup the money and trying to raise additional funds so that she can actually, replace her roof. So these things may happen more frequently than you may realize. FEMA recruitment. So at times, FEMA will determine that an applicant was overpaid benefits. So this often happens because applicant receive an insurance settlement after they receive their FEMA award. So FEMA award, especially with the new updates, will pay the applicants fast. And the insurance application or application for benefits may still be pending. So if any applicant receive insurance settlement after already receiving the FEMA award, FEMA may try to recoup that money. FEMA also finds that it's a duplication of benefits, they'll try to recoup it. It also sometimes happens because FEMA has changed the way they interpret their rules and policies. So in a recoupment case, FEMA is not alleging that the applicant did anything wrong in the application process, such as committing a fraud or not telling the truth, anything like that. But rather, FEMA is basically saying they made an error on their end in processing the application and overpay the benefits. Therefore, they want their money back. The recoupment process starts when an applicant receives something called a notice of debt letter. So the letter states that the applicant was overpaid benefits and needs to repay their benefits. So one major problem this comes up a lot is FEMA only often has the applicant's temporary address after disaster when they fill out the application. And people have moved on with their lives, and this address is no longer valid when FEMA sends out those recoupment letters years later. So when you have filed an application with FEMA, it's important to remind FEMA with your updated application, and also provide email addresses so that FEMA will have an option to contact the applicant by email or phone if the written mail correspondence may no longer go to the right address. When an applicant receives a recoupment letter and the applicant disagrees with the FEMA's determination, notice of debt, then the applicant does have a right to file an appeal in writing. The application has 60 days from the date of the letter to file their appeal. Again, similar to the initial appeal, when a FEMA application itself is denied altogether, it has to be written and have to have necessary information in it. What should you include in the recoupment appeal? So the written letter should include the following information. First, written explanation as to why the applicant does not agree that they owe the money. Number two, the explanation as to why there was no duplication of benefits. So it is helpful to show that the total cost of repairs were such and such an amount, less the amount the insurance paid, and the remaining amount that should have been covered by FEMA. So for example, if it cost $50,000 to repair the house and the insurance only paid $10,000 and FEMA paid $15,000. If FEMA tries to recoup that $15,000 saying you are already paid by the insurance company, the applicant can argue that is not a duplicate of benefits because FEMA money was not used to pay for the same repairs that the insurance proceeds, because obviously the insurance did not fully cover the cost of the damages. The letter needs to be signed by an attorney, and applicant's signature needs to be notarized. If the applicant is filing the recoupment appeal with an attorney representing them. They should also include photocopy of a state-issued identification card and include their full name, just the last 4 digits of their social security number, disaster and FEMA application number on every page of the submission. As you can imagine, as after a major disaster, tens and thousands of people submit these applications, and they may actually go missing or mixed up with somebody else's application. So it's very important that on each page that you submit, you enter the FEMA application number on it. FEMA says you can request an oral hearing, but they usually make their decision based on written documents. Once a decision is made and FEMA will enforce the recruitment decision, they do have right to go after people's wages for garnishment and levy their assets as well. Unfortunately, oftentimes the applicant is no position to repay FEMA because they probably spent the money to do the repairs and other things that it had to be done on the house. So the applicant can request in writing that FEMA not collect from them and explain their situation. They're gonna have to complete a form showing their monthly income and expenses to support the claim why they're not in a position to pay back the FEMA money. The applicant will need to write a letter explaining why it will be a hardship to repay the debt. And it's up to the FEMA after reviewing such a post-appeal letter, whether they can give all of the debt, some of the debt, or none of the debt if FEMA, makes a decision on those issues. The next topic I will discuss is disaster related insurance. So when a disaster strikes, it's important to know what type of insurance a survivor has, the type of disaster, and what was the damage that was done. And review the policy to determine if there is a coverage. And if there is a coverage, survivor should file a claim immediately. It's very important to file a claim within the deadlines because some of these insurance company will strictly apply the deadlines and may deny claims if they're filed late. When filing for insurance benefits, it's important to list the items that were damaged, provide receipts and estimate for any repair work that needs to be done in the future. These are the general steps when applying for insurance benefits. It's important to call the insurance carrier immediately after disaster so that they have a record that you incur damages. And then follow up with a written notice. Provide photos and videos. And if it's possible, make temporary repairs. Like I said before, it's important to make temporary repairs as long as it's possible to prevent further damage of the property. And you should do an inventory of damaged items or lost items and keep all the receipts and provide a list of expenses such as hotel stay, meals, and other medical bills, whatever additional expenses that survivors incurred as a result of a disaster. Always check for deadlines or any kind of special requirements that may be specifically required for that policy, and then send in proofs of loss with photos and receipts and things like that. And applicants should request partial or advanced payments so that they could start doing the work immediately rather than wait until the insurance company makes a final decision on the claim. It's important to document all communication, even if it was a phone call. Applicants should keep a log as to who they spoke, what was the nature of the conversation, and things like that. And if it's possible, document those conversations in an email or letters. Before signing anything that is provided by the insurance carrier, make sure that the applicant is not, releasing the insurance company from any liability or giving up of their rights. You should be very, very careful of the fine prints because once it's signed, it becomes a binding document, and it's recommended that before signing anything, those things should be reviewed by an attorney. I'll cover 4 different types of insurance. First is homeowners insurance. Homeowners insurance will usually cover fire, wind, lightning, or hail. However, it'll not cover damages caused by water, meaning any flood, storm surge, tidal water, tsunami are not covered. It also will not cover any earth movements such as earthquake, mudslides, or sinkholes. Falling trees must cause damage to the home or the property. Again, if the tree just fell on the ground, that will not cover it. If it's safe, request an adjuster to examine the damages so that they can properly evaluate the extent of the damage. And then document your losses and make all necessary temporary repairs. Do not dispose of any damaged personal property item until it's examined by an adjuster. Of course, this becomes difficult if the items are rotting or, will create mold and things like that. But however, if it's possible, you should keep them until an adjuster has an opportunity to examine. If it's not possible to keep them, then make sure to take photos. Once a claim is made, a decision will be made. An amount may be offered by the insurance company to settle, or it's possible the claim may be denied altogether. Again, FEMA will not pay for repairs covered by the homeowner's insurance. So what happens if the carrier denies your application? So usually those policies will have in the policy document itself how to appeal the decision, that it should be in writing. And it depends on each specific policy. So you're going to have to really refer to it. New Jersey Statute 17:29E-9 requires that companies to enforce internal appeal process first. If the homeowner or the survivor needs further investigation, they can make a request of the investigation of the claim to New Jersey Department of Banking and Finance and the New Jersey Department of Insurance Claims Ombudsman. The applicable time constraint on filing a lawsuit are policy specific, but usually policies provide 1 to 2 year period. In the absence of express provisions in the policy, an insurer might be able to argue 6 years to file a lawsuit, based on the contract violations. But it's important to refer to the policy to make sure what's the specific time requirement for that particular policy. The second type of insurance is flood insurance. So flood insurance companies are under the National Flood Insurance Policy Program, which provides insurance to help reduce the socioeconomic impact of the floods. So this is separate from a regular homeowner's insurance, and homeowners have to purchase this flood insurance separately. It's managed by the Federal Emergency Management Agency via about 60 insurance companies in the NFIP Direct. Flood insurance is required in high-risk zone and for properties that have federally regulated loans. But for homeowners who live in a regular and not flood zones, this is an optional flood insurance. So what does flood insurance cover? So under the flood insurance policy, usually it'll cover the property for any electrical and plumbing services. It'll cover appliances like furnaces and water and heaters. It'll cover carpets, cupboard, paneling, and bookcases that are permanently installed in the house. It'll also cover detached garages, clothing, furniture, and valuable assets in the property. Again, the policy is the controlling document, so you should definitely check, what the policy states about coverage. Usually, these items are not covered under flood insurance damage that is not direct consequence of the flood, damage inflicted by earth movement, even where it is a consequence of the flood. So if there was a flood, and because of the flood, there was a mudslide, or there was any kind of earth movement, unfortunately, the flood insurance will not cover it. It'll also not cover preventable damages like mold. It will not cover car damage, pools, fences, and foundations shifting. Third type of insurance is called renter's insurance. We recommend renters to purchase this insurance because usually the premium is relatively affordable. It's not extraordinarily expensive. And that's the only protection tenants have to protect their personal properties in the unit, because the property insurance by the owner will not cover anything that the tenant owes. So once you obtain a renter's insurance, it'll cover any damage caused by fire, lightning, or explosion, vandalism, theft, sudden and accidental water damage, and damages caused by weight of ice, snow, and sleet. However, renter's insurance generally will not cover any flooding, earthquake, infestation, intentional actions by the tenant or those in the tenant's household, or mold, except where the insurance policy specific covers it, which will probably have higher premium to have that extra coverage. The fourth and last insurance is the automobile insurance. So normally damage to a car from a disaster cover under the comprehensive policy coverage. But particular language and exclusions will control depending on what type of policy you have. Even when there's a flood, wind, and things like that, coverage may still exist under a collision policy if the disaster and event causing the damage could be construed as a collision. So again, this will depend on the policy itself and how the insurance company will make a determination on this issue. So how do you assess and renew an insurance decision to assess merit for an appeal or further action? So when a survivor files for insurance benefits under the coverage and it gets denied, what can you do? So from the attorney's point of view, the first thing is review the insurance policy first, confirm if the claim was validly denied or not. And the most important thing is review the coverage under the policy, exclusions, riders, addendums, and any related coverage documents. And if the claim was denied or underpaid improperly, an attorney or the homeowner or whoever is holding the policy can send a written appeal to the insurance company within policy prescribed time frame. An appeal should point the insurer to the sections of the policy showing that its claim decision was contrary to the policy coverage language. These are some of the general issues in any appeal when one files an insurance appeal for homeowners, flood, or renters. So the insurance company may argue that the cause of the damage or the loss is not covered under the policy. They're gonna argue flood water damage is not covered by the home insurance, and things like that, which is actually correct. There may be some disagreement about the amount owed to the insured or paid on the claim. So it's important to provide evidence of actual cost of the repairs, work, materials, things like that, if the insured will dispute the value of the claim. It's important to know what the policy provides for and what it does not, and comply with the policy deadlines. Missed deadlines can actually be automatically fatal to an otherwise meritorious claim. If there are any issues with the insurance appeals, you can contact New Jersey Department of Banking and Insurance or United Policyholders Association. The last topic I'll cover is contractor issues. Homeowners after a disaster are often very desperate to hire a contractor to fix their homes, so they do not take as much care as they normally would in hiring a contractor. Oftentimes after a disaster, major disaster, contractors, legitimate and also scammers, descend on the disaster area and go door to door advertising their services. New Jersey has the specific law under New Jersey statute section 17:16C-95 called Door-to-Door Home Repair Sales Act of 1968. So this act provides a limited right to rescind, cancel the home repair contract made at the consumer's home for 3 business days. So this right to rescind might be continuing if disclosure of this right is not made under case law Sweets versus Williams. So the contractor must advise the homeowner that they have right to rescind it within 3 business days. And if they fail to do so, the time may actually be extended. The Door-to-Door Home Repair Act provides that if a home improvement contract is signed at any location other than the place of business of the home improvement contractor, and if it is for an amount greater than $25, then the home improvement contractor must provide the homeowner 2 copies of a certificate which provides, number 1, the home repair contractor's name and place of business, the description of the goods and services sold, and last, indicate the amount of money paid by the owner at the time the home repair contractor was entered into. Once money is provided to a contractor, unless the homeowner knows the specific name and place of business and things like that, and the contractor disappears, it becomes almost impossible to get the money back. So it's important that homeowners are aware of their rights and receive and verify this information from any contractor. A 3-day right of rescission, that language should be no smaller than 10-point, bold-faced and typed in the contract, and the receipt may not contain a provision in which the homeowner waives his right under the Door-to-Door Home Repair Act. If the contractor regularly deals with the homeowner for whom English is not their primary language, then the contractor must provide 1 certificate in the language of the homeowners and the other one in English. New Jersey also has another statute, Home Repairs Laws and Regulation. New Jersey Consumer Fraud Act in New Jersey statute section 56:8-1 and later sections prohibits any fraud, misrepresentation, or unconscionable commercial practices. So this will prevent any contractor from committing any kind of fraud or misrepresentation in the home repair contract. Section 56:8.8-19 says, if ascertainable loss of money or property was incurred by a homeowner, then they could sue for treble damages and attorney's fees against the contractor. However, it's important to know the legal name and address of the contractor. Otherwise, if they disappear, it'll be almost impossible to claim these damages against them. Home repairs regulations of New Jersey Department of Community Affairs also specifically states, what information must be put in the contract. And there is a case law, Cox versus Sears Roebuck, that says violation of the home repair regulation is a consumer fraud action. So consumer can prove loss, with numerical estimate of cost of redoing the work. And even illegal debt demanded by the contractor could be ascertainable loss. Both the home repair and home elevation contractors are regulated by the Department of Community Affairs. So it's important for homeowners to do a research on the contractor before signing an agreement and before paying any money. Lawsuits may be of limited effectiveness and meaning for favorable outcome when the contractor is missing or insolvent or both. DCA and other methods for mediation or negotiation may benefit the client as a tool before and actually filing a lawsuit and following through litigation. And the both home repairs and home elevation contractors are regulated by the statute, including the Consumer Fraud Act. The last topic I'll talk about is preparedness. So although there are all these different legal issues that arise and assistances that are available, the most important thing is to prepare before a disaster strikes. For individuals, how can we possibly prepare for disaster? You should locate and protect important documents in a waterproof envelopes that are available now. And also create a family plan as to, when you have to evacuate, where are they, and if any family member is not together, how will they contact each other? So they have a family plan. And also check the insurance coverage during blue sky times to know exactly what coverage you have. And build an emergency kit. There are many commercially available emergency kits out there. And depending where you live, you may want to add items that you think, will be necessary. This is especially important for people who have some type of disabilities or medical needs or small children, because the needs of these vulnerable members will be much more important and serious in case of a disaster. And it's important to know what your rights are before disaster so that, when it actually strikes, individuals can deal with it in a more informed way. Preparedness for organizations, for different type of organizations, whether it be government or nonprofit organizations like us, and NJVOAD, which is a partnership of all these different organizations come together in case of disaster. It's important that we continue to do research, social services, so that we can provide assistance to survivors when there's a need. And we try to develop community partnerships and keep in contact. And also we keep our clients informed about their rights and these resources that are available. And also we have a list of the volunteers who will be available to assist with the recovery efforts after a disaster strikes. So it's important, again, before, during, and after disaster, that we need to be persistent, be understanding, and brainstorm solutions with the community together, so that we can fight for social inequity and for more social justice. That's it for my presentation, and I'll be happy to take questions now.
Thank you very much, Sue. And I think it's apparent in your very thorough demonstration, these programs are very complicated, and I'm sure that everyone, if they haven't already experienced it working with clients or themselves, how complicated all these programs can be and what the opportunities are, okay, for legal services to be of a tremendous help. Sue, thank you again for the presentation. And I thank all of you who participated for spending some time with us today, and hopefully coming up to speed on both the services that Northeast New Jersey Legal Services can provide, and actually the New Jersey Legal Services throughout the state and other counties, but specifically how they can help survivors recover from disaster. Okay, take care, and thank you very much again. Thank you, Sue, for the great presentation. Take care, everyone.
My pleasure.